No. And how you are. You're all right.
Okay, great. Welcome everybody to the Vermont Legislature's Joint Judicial Rules meeting. It is the 16th of October. Everyone has now filed their taxes and we're done with that. So we are ready to go. We have a full agenda, but I think we're hoping to be done sooner rather than later. So because some of them I think will move through quickly. Sorry, what? Is there something we need to know in the room?
No, I'm just having a hard time opening the legislative webpage.
Ah, okay.
But everything, it's online. Every other website will open, just not that one. So it's also covering.
Okay. Well, we're going to, does this mean that the public can't see the agenda? Is that the only concern there?
If they can see it.
They can see it. Yeah, it's there.
Yeah.
So your device is on Trump Connect.
Okay. Thank you. Sorry.
Great. No, I just want to make sure we're all able to function fully together. And I think we're all present, which is really quite exciting. This has not happened for a while, so this is great. Do we want to just quickly introduce ourselves? Or I'm Senator Allison Clarkson. I'm chair of Joint Judicial Rules, and I will pass it to my vice chair, Barbara Rachelson. Barbara, are you there? Whoop. Okay, then I will pass it to Tanya.
Senator Tanya Vyhovsky.
Randy?
Senator Randy Brock.
And Tristan?
Hi, Representative Tristan Roberts from Halifax.
And pass it to Tom.
Hi, everybody. Representative Tom Burdick from West Rutland.
Okay, and to Nader.
Hi, Senator Nader Hashim from Dummerston.
And to Barbara.
Representative Barbara Rachelson from Burlington.
And last but not least, Martin.
Representative Martin Malone from South Burlington.
Great. Terrific. Welcome. It's good to have everybody. I hope everybody had an opportunity to review Eric's the minutes Eric circulated, and I would look for a motion to approve those minutes and then have any discussion that we need to have. That was a hint.
So moved.
Thank you. Do I hear a second?
Second.
Great. Second?
Second.
Okay. Good. Thanks. So any discussion on the minutes as circulated? Okay. Guess not. I would then make a motion that we approve the minutes as circulated.
So moved.
All those in favor, please say aye. Or right.
Aye.
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 Great. Okay. All those opposed? Great. The motion carries and the minutes are adopted. Thank you very much, Eric, for doing that. Our first rule is a promulgated rule, which is challengingly already in effect, which is a little frustrating, which is part of what we're trying to get away from by having more meetings so that we can review these things. We don't want to be reviewing things after they've gone into effect. Sorry, Eric?
Yeah, sorry. Senator Clarkson, go ahead.
Did you say something?
No, I was just mentioning to Mike that you may want that rule on the screen because the substance
okay.
isn't there.
To present this rule, we have, who do we have today? Is John here or Shannon? Who is with us to present this? I hear silence.
I'm looking in our Zoom meeting, Senator Clarkson, and I do not see John Treadwell in there at this time. And if you want me to share any of our posted documents on the screen, just let me know and I can do that too.
Eric, I think what would be helpful here is this is a request to make permanent something that that was an emergency rule, as people will recall, during COVID. And it is the challenge that we have here is all we see is the language that makes it permanent. We don't see the language that we're making permanent. So what might be useful is if we could see the language of the rule itself. And Eric, you could walk us.
I think Eric did send that to us last night.
Okay, I was hosting a big event. I couldn't see, I didn't have a chance to see it. So, Eric, do you want to walk us through it in lieu of having anybody from judiciary to present it?
Well, the gist of it is, as you were mentioning, Senator Clarkson, that this was originally proposed or promulgated as an emergency rule in 2022 during the COVID emergency. And the idea was to permit courts to impanel a reasonable number of alternate jurors. You may recall that there were issues with having jury trials inside court buildings and being able to impanel enough jurors and getting people who were able to come and do that. So the idea was to have a longer list of potential alternate jurors in case they, were running into problems, either finding enough people or otherwise getting a sufficient number of jurors to participate. In fact, so that proposal, that rule was promulgated back then as an emergency order. The court, the committee, the Judicial Rules Committee did have a meeting back then and reviewed the rule and had no comments on it. So it also specifically said the rule, or at least the idea behind the rule, was that one of the circumstances under which, and I see that that Mike has just put up the language of the rule from 2022. So
Good.
So this kind of gives the committee a sense of what the actual language is. And Mike, could you move down just a little bit? There might be something that specifically says, see there it says in D1, that says a reasonable number of jurors in addition to the regular jury may be called. And the idea is that even for circumstances such as a public health emergency was specifically identified as one of the circumstances. The issue, as Senator Clarkson said, is that Attorney Weatherall and I had an email exchange about this last night. So we were kind of brainstorming a little bit about how we might address this going forward. The idea is that sometimes if the court is simply making a previous rule permanent, and if they're just doing that, as you said, Senator Clarkson, just with a one sentence rule that says, hey, we're making that other rule permanent without providing the substance, it's a little trickier to track down the underlying language. Not that it can't be done, because obviously I did it and we have it on the screen now, and Emily thankfully emailed it to me as well. But maybe going forward, there might be a way to think about how maybe with a link in the rule or something like that might make it more convenient for committee members to be able to look at the language of being made permanent. It only really applies in situations like this where the rule says we're just making a previous one permanent, as opposed to saying what it is, as you said, Senator Clarkson. Well, what is the language that's becoming permanent?
Right. And I'm hoping that we will, with our new schedule that we'll discuss at the end, that we won't have to go through this again. Because it's really frustrating to be reviewing something after it's gone into effect. It makes us seem, well, the senators can relate to this big time. So I would, any thoughts on this, for the committee? Anybody have thoughts on this?
Yeah, my hand's raised. Let's see.
Yeah,
So yeah, Elsa, I mean, I do recall having reviewed this. We did review the rule when it was an emergency rule, and we were fine with it. I do recall, and I would hope that if something was going to become permanent that we had any issue with, that's more of my concern. But I do recall we didn't have any concern with this rule when we originally looked at it.
I agree. It's not, it's the process rather than the substance.
Right, thanks.
That is concerning, that's all. Great. So do we actually, Eric, need to vote on this, given that we already have reviewed it?
You could, the committee posture right now is that it is in effect, is effective immediately, but because under the statute, the committee technically does have the authority to object to rules even when they have already become effective. You could, just for the sake of handling it consistently each time, just to vote either to object or not to object would be your decision at this point in time.
Great. So I would entertain a proposal to support the rule as promulgated, or as passed, or as in effect, or whatever the appropriate language is. Martin, you want to make?
moved.
Okay.
I'll second Tristan's motion.
Okay, great. Terrific. Thank you. All those in favor?
Aye.
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 Okay. All those opposed? Great. So the rule is now passed on from our committee into effectiveness, which it already was. So we'll move on to the second piece. I think we have two people who are here to present. Dixon and Jennifer, are you here to? Amy's here. Oh, how exciting. Do we have Mike, do we have? There's Dixon. Okay, great. So we have a promulgated rule. We have looked at this already. And this goes into effect in January. So this is sort of our new schedule, hoping to catch and review something before it goes into effect. And I think we will just, Dixon, ask you to comment on things as they stand now. Welcome.
Thank you. Thank you. Yes, my name is Dixon Corbett. I'm a Superior Court judge and chair of the Vermont Rules of Evidence Committee. The promulgated rule on gender neutral language in the rules is we took a comprehensive review of the rules of evidence. They included in 2024 the assumptions that all witnesses, criminal defendants, and experts would be men. So we have finally eliminated those references, but we also took the step of removing all gendered pronouns from the rules. There are no pronoun assumptions in the rules whatsoever, he or she or otherwise. The rules refer to nouns only. And we are very pleased with that. And we're very grateful to one of our members in particular, Karen McAndrew, a retired attorney, did a very thoughtful job in reviewing every single one of our rules.
Right.
We received no public comments when it was posted for comment.
Great. Thank you so much for this work. It is sort of interesting that we're doing it in 2024, but we began doing this quite a long time ago, as I recall.
We did, and there are many examples throughout both the Vermont statutes and other rules where this work or similar work has already been done. The Vermont Rules of Evidence had never engaged in even the preliminary steps of that. So we've taken the rules from, many of them were the same as they were originally proposed in the 1970s. We've addressed that and are happy to have done so.
Great. Well, thank you very much for this work. Any questions, committee?
Thank you.
Yeah. I think it's a big thank you and ready to go. So I think our objective here is to object or not, and I would make a motion that we agree to accept. And I don't actually know what the proper motion is. Eric, what is the proper motion?
I think you could, as you said, Senator Clarkson, you could move to not object, approve the rule with no objections.
Right.
Just an interesting, go ahead.
No, I'd look for a motion to approve the rule as presented and go from there.
So moved.
Great. Thank you. Second?
Second.
All those in favor?
Aye.
Aye.
All those opposed? Thank you very much. So carried. Thank you, Dixon, for your work on this. And please share Karen how grateful we are for this work. It's good to be done with this.
It is.
Great. Thank you very much.
You are welcome. There's
Okay.
a second.
Yep, we have a second piece that you are presenting, which has just been proposed.
That's right.
Okay.
So this is, there is an existing evidentiary rule that already protects the conversation where a person calls an attorney and says, I've messed up and need an attorney. And the attorney says, I can't help you, but please let me refer you to someone who can. The existing rule is the attorney-client privilege under Rule 502. It provides that that conversation can't be discovered or used in evidence in court. The plain language of that rule applies to the conversation between the prospective client and the attorney, regardless of whether an attorney-client relationship was actually created by that conversation. Before the pandemic, the Vermont Bar Association created a lawyer referral service, which is a phone number that people can call to seek information about available attorneys who might be able to help them. The service is staffed either by volunteers or by VBA employees who are not attorneys, and they listen to the caller's explanation of their situation and attempt to connect them with an attorney who can help. After the VBA created this service, Bob Paolini brought to the Evidence Rules Committee a concern that these conversations might not be protected by the existing evidentiary privilege because the service is not staffed by attorneys. So the concern was that the attorney-client privilege might be interpreted as not protecting that conversation. And although there are no reported instances in Vermont of a party seeking to discover the content of these conversations or use those conversations as evidence in a court proceeding, there are examples of this happening in other states that have lawyer referral services. So Bob Paolini brought to the committee these examples and also brought examples of solutions that have been adopted in other states. The Rules Committee reviewed these examples and conducted our own research as well. And we concluded unanimously that Vermont's Rule 502 ought to be amended to make clear that conversations between a prospective client and the lawyer referral service are protected in the same way as conversations between a prospective client and an attorney. The committee's solution is set forth in the proposed rule. Bob Paolini has reviewed the proposed rule, agrees that it addresses the concern of the Vermont Bar Association. And the view of the Rules Committee is that the proposed rule serves a valuable function and does not result in the exclusion of any otherwise admissible evidence.
Thank you. So that, from what I heard you say, Dixon, that also they're sort of one package. The lawyer referral and information service. It's sort of one package of. It isn't two separate things. Because I was looking for a definition of information services separate from lawyer referral, but it kind of sounds like it's the whole thing together.
That's correct.
Got it. Committee, this is our opportunity to make comments. We don't need to object or not. This is a comment period during the comment period, I believe. And so it's been sent out for comment. And so this is our opportunity for comment. Comments, committee. Martin?
Looks like a good idea to me.
It looks like a good idea to me too. I just was curious if we needed a definition of what that service is. Is that appropriate in any place to include a definition so people know what we're talking about?
The reason that the committee chose not to engage in further definition was simply to not impinge on any future changes to the VBA program and not to define it in a way that excluded some other similar program that may arise in the future.
Sort of options for flexibility. Okay, great. So I think, Eric, at this point, we just have the opportunity to comment, and I don't think we need to take any action. Is that correct?
That's correct.
Okay, I think this is a great idea. And thank you, Bob, yet again. Thank you, Paolini. Where are you when we need you? Right here, working on these rules. Thank you very much. And do you have one more? No, we have additional lawyers for this, or additional judges for this. Thank you very much, Judge Corbett. This was great.
Thank you as well.
Terrific. Have a lovely day.
Thank you likewise.
Okay, I think without further objection, we'll shift into family law. And so we lucky enough to have Amy with us too, which is great. So we have Judge McDonald, Katie, and Judge Davenport. Welcome, Amy and Carrie Ann. Are you here? Carrie, there she. Welcome. We have a promulgated rule. So again, our role here is to object or not object. And this goes into effect in January. So it gives us an opportunity to review it again and object or not object. And so would you two kindly take us through it and walk us through what we're considering? Thanks.
So Judge Davenport, I'll need to leave in about 2 minutes, unfortunately, because, and I apologize, Chair Clarkson, because I start my morning docket at 8:30, so I need to make certain that I'm up there starting. So Judge Davenport has been kind enough to be able to take over here, so I'm just going to thank her and just talk real briefly maybe about the Rule 1, the amendment for the juvenile delinquency proceedings. Terrific. But I apologize that I'll need to leave right after. So this is the promulgated rule of updating language within the Rule 1, which is the delinquency proceedings, specifically with competency evaluations. And if you look at the current language here, the current language refers to specifically mental examinations for juveniles. And what the language says here is whether the child suffers from mental illness or developmental disorder, including mental retardation. That's current rule. So this rule obviously clarifies and changes that language that we don't use so that it now reads whether the child has a psychiatric disability, mental health condition, or developmental disability, including an intellectual disability. Intellectual disability is the language that we use now. So we're replacing that and updating that in the rule.
Right. Thank you. We've done this before, but sort of finally more respectful language in.
Yes, exactly. And that's what it is, respectful language for that particular rule.
Terrific. Thank you very much. Well, in your 2 minutes, you did it.
Sounds good. Very nice to meet you. I apologize. It's a quick hello and goodbye.
Have a great day in court. Good luck.
Thank you very much. Thank you.
Yeah. Thank you for taking the time. Thoughts from the committee? I think this is great and is needed to be done for quite a while. So better late than never. Any further thoughts? Because I would look for a motion from somebody that we accept or that we not object or that we approve. What's the right word, Eric? It's like, I don't want to frame it negatively, like we don't object.
Maybe you could say it as approve the rule without objection.
There it is. So I would make a motion that we approve the rule without objection.
Can I ask a question? Can I ask a question about that? I know it's getting technical. Do we really approve rules? I thought really the only thing we do is object or not object. I mean, I don't know that it's our jurisdiction to actually be approving rules. Well, I know it seems like we are, but I think it's the only step we can really take is to object to a rule. And in fact, I would even suggest that the only motion that would be appropriate is if we object, and if we don't object, we just stay silent, frankly. Eric, I mean, am I off base on that?
No, I think that's also correct. I was trying to follow up with what Senator Clarkson was sort of trying to not to frame it in the negative, but I think that's technically true. So you could choose to. Sometimes the committee expressly says we're not objecting, and the minutes can reflect that. But your silence would also be taken as not having an objection. So it could go either way.
I know this is technical, but it's just. I just don't think that we actually approve rules. It's our action is to object or not.
Martin, this is why you're the chair of House Judiciary. And I am not even on Senate Judiciary. So I would look to you to make a motion that you thought was appropriate.
I would suggest that we don't have to have a motion if we don't object. That
Okay.
we would only have a motion if we do object. Wouldn't that work? I mean, if
That's even better. So
it's more efficient as well.
So how about this? How about unless I hear an objection, we will pass on to the next rule.
I love that. It's more efficient too.
Well, let me just ask a question, though. If we don't indicate that we don't object to the rule, or at least indicate that we have reviewed the rule, is there an absence of action on our part? In other words, does the record fail to reflect that we've done anything, that we've even heard it if we don't say anything?
So the minutes, Senator Brock, the minutes always reflect that there hasn't been comments and there hasn't been an objection. So Eric always captures the fact that we haven't objected. If you look at the minutes, you'll see that that's the case.
Which still, sadly, is cast in a fairly negative. I mean, I just wish that, sort of like Randy, I wish we had sort of an affirmative way of supporting it rather than just not objecting. That's all. You know me, the Pollyanna of the Senate. Anyway.
I'm just inclined, just from the standpoint of clarity, to at least say what we did, even if we did nothing, as opposed to being entirely silent. And that just, in my mind, raises a question. Somebody's got to go look at the minutes and decide what it is we talked about, if anything.
But I think the action will be represented in the minutes that we didn't object. The committee chose not to object, and that is the action, I guess.
And in part, looking at this historically, that's the way that we've done this for the 10 years that I've been on the committee, is we wouldn't have a motion to approve. It would only be an action if we objected. I'm happy if the rest of the committee wants to make it very clear, but I would then have the motion that we do not object. But I just don't think that from our historic procedure that's necessary. Again, I will double check that I'm saying the right thing and have the right memory of this to Eric.
But the action will be represented. The action will be represented in the minutes.
Yes, I'm just looking at the minutes that you approved earlier, for example, of just the languages in similar situations, the committee had no objections to the rule.
Right.
Good morning, everyone. I wanted to apologize for being late to the meeting.
We missed you, John, but we actually discussed and passed, and we're all set. So
okay.
You have a great day, unless you have something else to share with us.
I don't believe so. I think it was very straightforward, the issue regarding a juror selection and just continuation of the existing.
Right. And the only thing we had modest concern about is when we're asked to make a rule permanent, that we actually see the rule that we're making permanent and not just the proposal to make it permanent. Okay. So we saw that, we looked at it, and our thumbs are up and we're all okay. And it's already in effect anyway, so it didn't much matter.
But again, my apologies to the committee and to the other witnesses for being late.
It's okay. These things happen. It's good to see you.
Good to see you all. Thank you.
Have fun.
Bye.
Thanks. So are we okay with not objecting and having that reflected in the minutes as our action? Okay.
Yeah.
Great. Terrific. Then let's move on to the second promulgated rule. Again, this is an objection or not object. Again, will go into effect in January. And Amy, would you be kind enough to take us through this and the next one, please?
Sure. Just for the record, I'm Amy Davenport. I'm a retired judge and I am the reporter for the Family Rules Committee. The next one is one that you have actually that you reviewed in June. It's an amendment to Family Rule 15, which is the rule about appearance and withdrawal of attorneys. It eliminates a subsection I just because it's obsolete. It is a procedure that was put into place initially before the current case management system when the court first started electronic filing and required attorneys to register in something called e-cabinet. E-cabinet no longer exists, and this amendment simply amends the rule to eliminate this subsection.
Great. Thank you. Yes, we did review it, and it does. I'm just going to put a marker in here because it raises our favorite subject of Odyssey and how it's doing. And so I would ask that when we have our conversation at the end, I don't know if Emily's watching. I hope she is. Emily, I'm going to put a pin in for an update on how Odyssey is doing and how people are feeling about it this many years into it. And how, just how its functionality is working. So I would say that without objection, we will move on to the next one. Are there any objections, committee? Great. So without objection, I would suggest we move on, Amy, to the next one, to 5B. I mean,
Okay.
6A.
Six, yeah. Okay, this is an amendment to two of the family court rules, 4.1A2 and 3 and 4.3. This comes out of legislation that was passed, I think initially it was passed maybe in 2018, and then it was completely revised, and I think in 2020. But it is legislation with respect to the special immigration status for juveniles. And under federal law, and the reporter's notes do give you specific citations to the federal law. The federal law allows, basically creates a pathway to for juveniles, a pathway to citizenship if they have been abandoned or abused by one or both parents. And so it is but in order to file for that special status with the INS, you would need to have specific findings there would have to be a court that had some jurisdiction over the child, and a court could have jurisdiction over a child in a number of ways, which I'll go into in a minute. And then the court would have to make special findings. So the court could have jurisdiction over a child through a divorce case, through a parentage case, through a CHINS case, a child in need of care and supervision. It could have jurisdiction over a child through a guardianship case in probate court. So there's just a number of ways in which a court, a trial court, can have jurisdiction over a child, and where this procedure would come into play. The special findings that are required from the court that does have jurisdiction is that the child is a dependent of the court, or legally committed to or placed under custody of a state agency. That's number one. Number two, the child has suffered from abuse, neglect, abandonment, or similar circumstances. Number three, the child may not be viably reunified with one or both parents due to abuse, neglect, abandonment, or similar circumstances. And four, that it is not in the child's best interest to be returned to the child's or the child's parents' previous country of national residence or habitual residence. So in a case where, for example, a parentage case, one parent who happens to be in the United States with another parent who lives elsewhere and who has abandoned the child, the parent who lives in the United States could request that the court make these findings in the context of the parentage case, to make these special findings. And so Vermont passed legislation that required, that laid out the parameters for how this would happen. And that legislation applies both to the family court and to the probate court. And within the family court, it applies to parentage and divorce cases on the one hand, as well as abuse and neglect cases on the other. Initially this came to our attention, the question of whether we needed special rules for these cases came to our attention because the probate court rules committee contacted the family court rules committee and said, let's have a joint meeting and talk about this. And at that joint meeting, we asked a professor from Vermont Law School who was in charge of their special immigration clinic to come and talk to us about whether or not there were problems with either the statute or the rules, but specifically with the rules that the rules committee should address. And there were two issues that came up with respect to the family proceedings, specifically divorce and parentage cases. There were no issues that came up with respect to abuse and neglect cases, but with respect to divorce and parentage cases, the two issues first had to do with service. So the statute says that service can be waived, but the rules that govern divorce and parentage cases do not currently permit waiver of service. The second issue that came up was case manager hearing, meetings with the case manager, which normally precede any hearing in front of the judge. And that a case manager, a conference with the case manager doesn't really make sense in these kinds of cases, at least until the court has reviewed the request for special findings. And usually there is a need to expedite getting the special findings. So, so the rules that are before you amend the rules related to parentage and divorce cases in both of those ways. And I can walk you through the specifics unless there's some questions about the general background.
I'm fine. Committee, do you have questions?
I do, but I'm going to wait until we walk through the details to see if they stay.
Okay. Okay. So if you, first of all, Rule 4, 4.1, 4.2, 4.3, I don't know to what degree the committee is familiar with that particular family rule. It used to be one huge rule, Rule 4, and it was enormous. And a number of years ago, it was divided into subsections because it just got too complicated. So Rule 4.1 is are the rules that relate to the initial filing of parentage and divorce cases. And in this case, the two changes that are proposed is one that will allow service to be waived in these special cases. And you'll note that it then refers to Rule 4.3, and I'll get to that in a minute. And then in the other change is to subsection D, let's see, 3D. And that would allow, in cases where there's a petition for special findings, the matter to be set immediately for a hearing on that motion, and the case manager conference postponed until the petition has been decided. then going over to Rule 4.3. Rule 4.3 is a rule, is a subset of the Rule 4 proceedings that impact divorce and parentage proceedings, and it deals specifically with special proceedings. And in our view, this is a special proceeding. So in the amendment to Rule 4.3 outlines the procedure to waive service. In order to waive service in these specific cases, first there would have to be a motion to waive service. The motion would have to provide certain information, the names of the child's parents, if known, or if one of them is unknown, that needs to be specified. Location of each parent, including the current address, if known, and if it's unknown, that has to be specified. If the name of or location of a parent is unknown, a detailed description of efforts that have been made to identify the parent or determine the parent's location, including the parent's address and county of residence. So they need, and country of residence, sorry. And so they need to kind of say what they've done to try to figure out where this other parent lives. And then finally, the reasons why service cannot with due diligence be made by any other prescribed method, including service by publication. So we wanted to frame this in a way, first of all, to outline a procedure and outline what we thought judges would need to know. And we wanted to frame it in a way that allowed waiver of service, but allowed waiver of service only if no other way to serve the other side was possible. And then the second part of that section, subsection 2, G2, just requires the court to issue findings along with their written order. Because we at the Rules Committee level, waiver of service is a big deal. Basically, you're allowing the court to proceed and you're saying you don't need to serve the other side. You can just go ahead and you can make decisions without the other side knowing. Probate court already has a provision that allows for waiver of service, but the family court in these cases has never had that kind of provision. And we've constructed the rule so this is exclusive to these proceedings and not generally available in a divorce and parentage case.
Thanks. Maybe take a moment. Tanya, was your concern or question answered?
For the most part.
Yeah, I can see that that there may be cases where parents in other countries that are going through huge civil wars or I mean, some of the frightful stuff that people are fleeing from, that it might be very difficult to be able to serve that parent in that situation. And so I can appreciate the court's need to not keep dragging the case on for the child and so I can appreciate the need for this. Other comments from the committee?
Actually, it's the statute that says that service can be waived. It just doesn't really describe what the procedure would be, and that's what rules are for.
That's what rules are for, is to flesh out the procedure. Great. So we created the statute. We passed it in 2020, I believe, and
the second round, yeah.
Second round. And so this is the rule that is helping make it feasible.
Right.
Tanya.
Yeah, no, I appreciate the need for it and I appreciate the clarity and I really appreciate you walking through it that clearly. My sort of concern and unease comes from, if a country is going through great upheaval, has that parent really abandoned the child, or is that parent caught in just that right to be part of the process? It just, as the judge said, waiver of service is a big deal. And so it makes me a little uneasy, but I appreciate how clearly it's laid out and how much effort is in that to make sure that people are involved if they are able. it's that balance for me of
Right.
making sure that that child really has been abandoned, that parent has their full rights, because I've certainly seen borders used to kind of manipulate that system and take kids away from parents who do want to be in their child's lives.
Yeah, I quite agree. And that is one of the special findings that obviously the court has to make, is whether or not there really has been abandonment and what evidence the other parent is offering in order to make that finding. But that finding is necessary in order to get these special findings.
Any other comments, committee? Martin, I can't see if you have your hand up, so you have to wave.
No, I'm good.
Okay, great. Anybody else? Okay, so I think then the second half, Amy, the 4.3, the subset of no, the case management, the postponing until after the postponement until after the findings are heard at court. I'm fine. That makes total sense to me. But rest of the committee, any comments? So again, Martin, you're just going to
No, none here. None here.
Okay, great. So I think we are seem to be in sync with the rules committee. So thank you. Thank you, Amy, for that hard work. That was
Well, it is the rules. These rules are out for comment. So far, Judge McDonald Katie let me know that she has not received any comments, but they are currently out for comment. I did want to give the committee a heads up. I really appreciate having, for a number of years, followed the LCJR proceedings. We are currently looking at a rule change that has resulted from Odyssey. It was not one that was initially foreseen would be a problem. We have a proposed rule that we are going to be voting on a week from Friday. But if it is approved by the committee, we may well be asking for it to be promulgated as an emergency rule. It is the current rule is not workable given Odyssey, and that snafu, the fact that there's no workable rule is causing huge delays, I am told. So in getting cases moving. So we will, I just wanted to give the committee a heads up, because I'm really very excited to hear that you are trying to get not have rules come to you after they've already been promulgated.
Right. I mean, that does seem sort of pointless. How soon you're going to have that this week, do you think?
We will, the committee meets a week from Friday. At that meeting, we'll review the rule has been, we have a proposed rule from a subcommittee that the committee will be looking at. And we will also be discussing the possibility of asking for an emergency promulgation. Whether or not the committee will decide that they want to do that or not, I have no idea. But it is a concern.
Right. Well, and any backlogs that rules are a barrier to, that's a challenge. So
it is at this point causing a backlog just because the rule is unworkable.
And it's a piece of Odyssey that is creating that problem.
Well, it's Odyssey created the problem in a way, really electronic filing and having electronic files. It's something that probably we should have foreseen. It's a problem that probably should have been foreseen, but it would have been hard. I mean, I think that's one of the things that's happened is, as a result of electronic filing, you find these these little places where things just don't work the way they used to.
Right.
And when you had paper files. And this is an example of that.
Got it. Can Emily give us a tiny bit of a window into that when she does her Odyssey update, we hope, at the end of the meeting?
I have not had a chance to really talk to Emily about this particular rule. So other than talk to you about emergency rules and how they work, which is what I need to talk to her about.
Okay. And is this an issue specific to family court, or is this
it's an issue specific to family court? It has to do with it's specific to divorce and parentage cases and post-judgment motions.
Okay, great. So we will figure out how we can, if needed, pull ourselves together to help with making that move along, because we don't want to be a barrier to that movement either.
Okay, great, wonderful.
Okay. So
and I would give you more information, but I feel like I can't get too far ahead of the committee.
It's okay. So I think without a comment, we will move ahead. Amy, thank you so much.
Welcome.
This is terrific. It's always good to have you, and it's great to see you. Okay, we will now move to number 7. I think we have Alan. Do we have Alan here to present it?
Yeah. I'm turning on my video. Can you hear me?
There you are. It's good to see you.
Good morning.
Good morning. We are already, oh my gosh, we're ahead of time. This is so exciting. Thank you for being available ahead of time. So, we are, I think we are, this has been promulgated. Our posture here is to object or not. Alan, if you'd be kind enough to give us just an update on this rule, that would be great.
This is the foreclosure rule.
Yes, which we have discussed before.
And the amendment requires the plaintiff to include with the summons when it is served a couple of forms, a verified answer foreclosure case form and a blank notice of appearance form.
Right.
This is a little bit of catch up to, I think it's maybe 2.5 years ago. We had already required serving a notice of appearance form. And of course, this is to aid self-represented litigants. And 2.5 years ago, we added the requirement that an answer form be served. This was in Rule 4 in the general rule on service. And of course, foreclosure answers have to be verified, and the answer form, general answer form, is not verified. So Civil Oversight has developed a verified answer form for use in foreclosure, and we now have a rule in effect as of January 1 that specifies in the foreclosure rule that the verified answer form is the one to use.
Great. Thank you. Thoughts from the committee? So without hearing objection, I would suggest we move to, this goes into effect in January. Is that right, Alan?
Yes, January 1.
Right. Great. Again, so this is what we're trying to shift, is make sure that we see these things. We have our last opportunity to object or not object before it goes into effect. So I think this is working the way we were hoping it would work, right, Eric?
Yeah, process-wise, the rule itself, I don't know. but yes, process-wise, it's exactly right.
But it sounds like we have no objections, and so let's move to the next one, which is 4C, which is the sheriff one. And Eric, did we have any luck getting the Department of Sheriffs and State's Attorneys to join us?
Nope. I emailed them and heard back from at least one of their reps that they weren't available, and didn't hear back from anybody else. So
okay.
But I did send them the language of the rules, so they have it.
Great. Terrific. Thanks. So Alan, would you be kind enough to take us through this?
Yeah, the existing Rule 4 on service of process requires a sheriff or deputy sheriff. but it also allows the court to specially appoint any other person, as the rule said, freely, if that would result in reducing the costs.
Sheriff Anderson.
From time to time, I get complaints that why can't we use any adult person to serve process? That's the way subpoenas are served. That's the way it's done in federal court. Many states have that system where anybody can serve process, not just a sheriff. And I've not brought it forward on the agenda until through Eric, there was an inquiry from Senator Hassim, who had also had some constituents complain that there was delays in service of process. So the committee studied whether it would be a good idea to allow anyone not a party to serve process. And we contacted the sheriffs, we contacted Private Investigator Association. We talked with legal aid, and we looked at what had been done in other states. I did not a comprehensive survey, but as I said, a handful of states allow any person to serve. I found in one state they had gone from the old system to that system and then came back, evidently having problems with service by anyone. And the committee felt it was, there wasn't enough oversight, perhaps, of letting anyone serve as a matter of right, but that we could amend the rule to highlight to council that you can get alternate service if you make a request to the court. And so we added language that makes that freely available, as it already is, to save cost. But now it says freely and promptly without awaiting any response, or as proposed, freely and promptly without awaiting any response by the other parties who have entered an appearance, when substantial savings in travel fees will result or for good cause shown. So the hope is that that through the judges will mediate exactly who will be appointed to make sure that they'll be reliable, that the service will be effectively notify people.
Right.
So without making a general permission for anyone to serve, we've tried to highlight that if you are in a time pinch, this process is available. It's not going to be an adversary process, but between you and the judge. And the judge, the theory being the judges all, if they have success with one person who's appointed who does it well, then that person, may become routinely approved by a judge. So it's kind of experimental, and it's out for comment.
Right. Nader, you seem to have had experience with this. Nader Hashim is right with us. Did you have some thoughts? Because it sounds like you've handled it thoughtfully.
Thank you. Well, first, I just wanted to thank Mr. Keyes for presenting that and taking it into consideration with their committee. Yeah, it was something that was brought to my attention both by constituents and with the work that I've been doing. And it was more so an attempt to kind of bring us in line with what the federal government does and what a number of other states do in terms of who can serve in civil process, because I mean, the main complaint was that, sheriffs, they try to, serve process, but, often it can be a bit challenging, depending on staffing levels and timing for to meet any deadlines or anything like that. So, yeah, that was the idea, and here we are.
And how do you feel about what they've proposed so far? It seems good.
Yeah, I mean, it seems like they did due diligence, and I mean, I'm fine with it. I think, yeah, I'm fine with it as it's proposed here.
Right. Any other comments? Martin, do you have a comment?
Well, just a question. Sheriff Anderson
can be available if we want him to join on Zoom, if you want to get his input. I don't know if that's necessary for this particular rule at this point, since there's a comment period, but I just wanted, he had texted me and said that he is available. He just got the email from Eric, or just got to the email. And if you want him on, I can ask Mike Bront to send him the Zoom link.
Nodder, have you spoken with Mark? I mean, are you two in sync on this, or what?
It was a while back when we spoke, maybe a year ago. So it's, I think there was some concern about, actually, I can't remember off the top of my head. He did have a concern, but I can't remember specifically what it was, because it was quite some time ago when we spoke. But I think that what was proposed, what Mr. Keys just discussed, seems to be a good middle ground for addressing the issue, but also mitigating some of the potential concern. But if we want more clarity on what that concern was, I think having Sheriff Anderson in would make more sense.
Right. So, Mike, why don't you just invite Mark? I don't think it would be great. And then I would hope the sheriffs would send their comments in to the committee, to the Rules Committee.
Invite sent.
Right. And Tanya, you have a thought while we're waiting for Mark to join us?
I do. I'm wondering, as I'm looking at the rule, and I hear the conversation talking about reliability. My concern is also in the safety of the person being served, particularly in civil spaces. If someone is being served divorce papers from an abusive partner who is accessing someone to provide alternate service, who meant really to continue to terrorize that person. So I don't see anywhere in the rule that the judge has to do any type of vetting. Does this person have a history of, violence? Does this hurt? So I just want to be really careful that as we're thinking about alternate service, that the people that are being selected to do alternate service have some level of safety vetting for going out and knocking on people's doors. I feel like I'm rambling a little bit, but hopefully my point is getting across.
And your point is clear, I think. I think it's a good point. Alan, have you discussed that? I assume you.
Yeah, we not that specific context, but the reporter's notes. Our process was we did discuss that in committee that the judge would be looking at the candidate and making sure that would be a reliable and appropriate person to be doing the service. On the fly in committee, we had a proposed reporter's notes that talked a little bit about that aspect of it, not only the reason for appointing someone, but who the appointee would be, and it got taken out of the reporter's note. So we will, I guess, take that as a comment and the committee could decide whether to include something in the rule or perhaps something in the reporter's note to remind judges that they should vet the candidate,
or further vet what appropriate means.
Yeah,
I think that's good. So Mark Anderson, are you with us, Sheriff? It's good to see you again.
Madam Chair. Likewise.
So we're in a comment period on this rule. And it seems like you and Nodder discussed this a while ago, and the rule has taken into account some of Nodder's concerns. What at this point, have you had a chance to review the language that they're proposing?
Yes, Madam Chair, I received it last night. For the record, Mark Anderson, Sheriff Windham County, President of Vermont Sheriff's Association. We did review the language last night. I'm literally working on my draft of comments to Eric right now. And then I was watching the committee as this came up. So somewhat.
We'd love your comment if you would like to share it with us.
Thank you, Madam Chair. So this is somewhat from the hip, based on my recollection of the conversations from a year ago with Senator Hashim. The original concerns that sheriffs had, we recognize some of the issues. in some counties, there's issues about service, lack of staff, whatever it may be. And one of the restrictions sheriffs have as it pertains to civil service is we are constrained to our counties, whereas with criminal process, we are statewide officers. I was working with Representative McCarthy in House Gov Ops regarding some of the issues that were going on back in, I want to say it was February, March. And my understanding is that we either fully satisfied the issues under present law, or at least the issues were resolved for now, but we have continued conversations with regards to it. Concerns with what other states have done regarding allowing anyone to serve civil process. We've seen a lot of issues, and we've also seen it here in Vermont under current rule and current law pertaining to improper service or people who are serving it incorrectly. And the concern, one of the concerns I raised, and this was based off of an action with the constable who would be qualified to serve process. We were called a 911 call for a burglary or breaking, a person breaking into a home. We arrived to find the constable from Brattleboro attempting to serve a process. He's actually not qualified to serve under current law, but attempting to serve it in a town outside of the town of Brattleboro. And the person that was being evicted was saying, I don't know who this person is. I've never received any notice. And what we found was the documents for service were just stuffed underneath some items on the porch. So she had never received them, never been presented them in hand. There was no alternative service issued by the court. And so it's just like, as we're looking at this and the sheriff being responsible to effectuate a writ of possession or an eviction, we're looking at this and saying the entire process, we believe up till now, has not been affected correctly by a person who is technically authorized by law to serve process, but not this process. And we would own the liability if we effectuated the court's order, which at this point is invalid. So now we put the landlord through even further expense to say you need to go through all the service all over again because the person you hired did it wrong. That's but one story of many I could share. And so to Senator Viofsky's concern about the vetting of people, our employees are going through significant background checks with adult abuse registries, juvenile abuse registries, like all the protective databases that we have access to, we are checking as we are vetting employees. And one of the concerns that we are looking to improve in statute was how to do this. Reviewing the advisory committee's recommendation on Rule 4, I do see it as a middle ground, I think was the language Senator Hashim used. I'm not sure that all the sheriff's concerns are wholly absolved with it, but I think that as we consider how we ensure people who are insured, who are qualified to serve process and trained to serve process correctly, so that it's not upsetting a plaintiff's ability or a defendant's ability. There are also, I think, when we talk about cost and or speed of process, there was a complaint in my county about speed of process. We started collecting data, and that will be submitted in our comments. And what we showed is that we're actually on average serving in under 10 days. We were being told felt like 3 months. And in some cases, we found small offices were not as organized. It's what it was. But there are also other opportunities that states around us use, New Hampshire, New York, Massachusetts, that do improve process service delivery because we do have to ensure the person received the process as opposed to tacking it to the door or sticking it on their car or some things that are allowed in other states. And I'm not saying that that's what should happen or shouldn't, but I think there is opportunity to talk about ways we could speed up and make it less expensive to serve process. That is kind of my high level comments as of right now, but I am working on polling the sheriffs to get where we are as far as position on this piece. Our concern is that we just don't want to see poor service that then comes back on us to clean up the mess. And we also want to absolve the liability that we face in serving process, which honestly, I'm more concerned about the liability serving civil process than I am with the law enforcement work my department does.
Thank you, Mark. That's helpful. One of the challenges, of course, is, as you've already mentioned, the inconsistent ability of all sheriff's departments. So that there is one of our challenges.
And yes, Madam Chair, the recommendation that we had given earlier, it was just too late in the session when we were talking about the problem, was to expand with 2 words, expand one section of Title 24 that constitutes the sheriff's authority. And so it would still allow for the process to work the way it works right now, but it would give me the authority to say the sheriff in whatever county is unable to do this for whatever reason, I can take the drive up and do that. Just like it does with law, criminal law.
But for the moment, you feel, and you're going to get your comments into the committee. At the moment, the middle ground seems to be at least a good starting point for comment and to build on.
I would agree with that, and just with the caution that we want to make sure we have qualified, competent people doing this, not just someone who's not involved, who's over the age of 18, and that has been problematic in other jurisdictions.
Great, thank you very much. That's helpful. Any other comments, Martin? I think you've got
just a couple things for the Rules Committee to consider. Right now, I mean, the current rule as it stands doesn't have any real check on how qualified, and all it requires is an indifferent person. And if the Rules Committee can look at whether there can be a little more language there, like qualified or trained or something, or at least in the reporter's notes, also reflecting Senator Bahowski's concerns on that. So that would be one comment I'd make. The other is if everything seems
is that a proposal for us, Martin, to agree with?
Yeah, that would be sure. Yeah, if that wants to be the comment from the whole committee as opposed to just from me, that would be fine. But I think just given that concern that we just heard from Sheriff Anderson, that would be appropriate for the Rules Committee to look a little bit closer at that particular issue. I would make do you want to finish on that one? And then I had another comment I want to make.
I would finish on that one and then move to the next one. How about that? Any feelings on the committee? I would support that motion and that comment and ask that we as a committee file that comment with the Rules Committee, with Alan's committee. That okay with everybody? Okay, great. What's your second one?
Yeah, the second one I'll take it. It's just a matter of if things are going to be going better with the sheriffs and whatever changes may happen through government operations. That just means that perhaps good cause wouldn't be shown. I don't think that means that we should not have this rule. So I think this otherwise the rule and the procedure makes sense to me. That's all.
I would agree with you because there may be instances where the sheriff is an inappropriate, person to be serving. Alan.
Yeah. Would Mark also send his comments to me for my committee? That my name and address is on the website where the rule is posted.
I can do that.
Thank you.
Great. Thank you so much, Mark, for taking some time to join us. We appreciate it.
Thanks, Mark.
Thank you for having me. See all of you.
Any other comment before we move on? This is why this is good. I like it when we're in a comment period and not just objecting or not objecting. Okay, Alan, then I think we have our last one, which is 9.2, which is the making permanent, yet another making permanent without the language of what the original thing was. So, I guess with this one, I would ask, we have a landlord-tenant task force this summer looking at evictions. I'm very discouraged that it hasn't yet met because it's a big subject, and I'm really concerned that this work has yet to be started. Tanya.
We are having our first meeting next week.
Oh, good. At the end of October.
Yeah, there are lots of reasons, and I can chat with you offline about how that happened. I'm concerned as well.
I'm very concerned because this is a big subject, and I would hope that you would weigh in with this committee that is doing this work, because I would hope they would be done in coordination rather than making a rule that then this this committee is already looking at something different. So I would hope that this was done in coordination with that work. Is I guess the pin I would put in this.
Yeah, I certainly perked up when I saw it for all the reasons you've named, and I'm on that commission, the landlord tenant.
I know you are. Was delighted to see that. You and Richie, right? I think you and Richie are on it for the Senate. So Alan, you want to flesh this out with us?
Sure. This is a COVID era rule. The federal government in the CARES Act put a moratorium on evictions, and they also put a restriction on requiring a 30 days notice of certain evictions. And that requirement, we're calling it the CARES Act notice requirement. Unlike the rest of the parts of that act, is as far as we know, is permanent. It doesn't expire. And there doesn't seem to be any prospect that it would be changed. We adopted a rule to implement it on the theory that between the tenant and the landlord would be the one who would have the most access to the information as to whether the property was a covered property. It had these federal loan connections or federal guarantees. And there is a website that the instruction where you have to enter the social security number of the landlord. And the instructions on the website say only the landlord, the person who has the social security number, can use it. A landlord may be ignorant of whether the loan has been sold and become backed by the federal government. And so in a process that involved the Landlords Association and legal aid, this rule went back and forth maybe several times, along with other rules that are now expired. But it basically says when you file an eviction, you either have to certify that you're not a covered property, that is, that you can't find on the website that your loan is connected to the federal government, or that you've complied with the 30-day notice requirement. This applies under our rule to residential evictions where the grounds for eviction are non-payment. And the rule is implemented through the form, but the rule says, which you don't have in front of you, I guess, it says
yes, we don't have the language. So
yeah,
would you like us to put it up? Eric and Mike, do we have the language? Because this again is one of those things where we're asked to do something, make it permanent, but we don't have the language that we need to be considering to make permanent.
Do you want me to pop it up?
Yeah, exactly.
Thanks, Mike. That would be helpful.
Exactly.
Yep. Doing it right now. Sorry.
Wonderful.
And here you go.
Can you make it a
Okay, there you go.
Gotcha.
okay. So is this it, the striking of C? Where is the permanent?
No,
where's the actual language?
It's the whole.
Yeah, it's before C, A and B.
It's A and B, right? So I thought, okay.
Now this is all that's left of Rule 9.2 is A and B. So the first section A says it applies to residential evictions for non-payment of rent. The second B says you have to have a declaration that you complied with the CARES Act. That's paragraph 1. 2 says it must be in the form approved by the court administrator. And 3 says the court may dismiss the case if it's filed without the declaration. This rule, by terms of the promulgation order, will expire next September. And I tried to get a jump on it in case there is a need to make revisions to the rule. We'll have time to make proposed rules, go back through a comment period and come back to you before this rule expires. But I did contact the Landlords Association, and as far as they're concerned, there have been a few glitches, but not necessarily with the rule as I understand it. That the use of the form, according to the landlords, is helpful. All they have to do instead of go to the rule is look at the form and follow what the form says they have to do, which is look up your property on the website and attach the results of your search if it shows you're not a federal property, or that you gave the 30 days notice. I've also talked with legal aid informally, they haven't made a formal position, but their perspective seems to be similar, is that the process is working, the form is there, people are, they told exactly how what and how they have to comply with the rule. And so we sent it out for comment. I was on top of the mountain back of my house on that Tuesday when the rule came out in the morning, and I received a comment from one of the judges, who says, if I can paraphrase, that the issue she sees is with unrepresented landlords that sometimes they don't use the form, or they fill out the form incorrectly. And she thinks that happens enough that maybe we should take a look at that. Also, that the provision in the rule B3 on dismissal, maybe that's a little too harsh. It seems the judges are exercising their discretion and sending people back to complete the form rather than dismissing the case, as I understand it. But it may be a little bit too much overkill to say you filed your lawsuit, you've attempted to comply with the rule, but there's some small problem with it, and the judge, you may end up having to pay a new filing fee and start all over again. So we have one comment so far.
Thank you, Tanya.
I just want to make sure. So the way I read 3, I'm assuming that in the rules, it is the same as statute. It doesn't say that the court shall dismiss the case. It says that they may dismiss.
May.
Okay.
And so it's a question of what's happening in practice. And as I said, my initial inquiry, the people naturally to ask was legal aid and the landlords, is neither one had any difficulty with making the rule permanent. But there may be some judges who perhaps would like a little more clarity about 3, or some modification to the form.
Right. Any other comments from the committee? Martin?
No, I actually was just telling Eric to let you know that I had to duck out for a 9:30 meeting. I apologize. But I didn't have any issue with any of the rest of the rules, so.
Oh, okay, great. Terrific. Good to know. Barbara, I think also, Barbara, are you still with us? Because I think Barbara also had to duck out. And I know Tanya has to leave in a minute, so in a bit. So I'm cognizant of this. Tanya, how do you feel, and Alan, how do you feel about this? I think this may be independent of when are comments due? Comments are closed when? December
9, I think.
I'm not sure, Tanya, how I feel about. I think this may be a little separate from the committee's work on the eviction work. What are you feeling? I think this could probably. I don't know. I'd be curious to see what your thinking is.
I think it's somewhat informative to me about like what the process looks like, but my understanding is largely it is complying with federal law. Like it's simply aligning our process in compliance with federal law.
Right. I would agree. So I guess what I'm trying to say, not as well as I might, is that I think we could continue without, although I think, Alan, it would be interesting for you to check, to be aware that there is this landlord tenant and any work going on with this task force, which is meeting, I believe, next week, which is.
I saw the legislation establishing the task force, and we don't have a rule on evictions. There's all the procedure for evictions is statutory, and
right.
And that seems to be working. I mean, no one's come to us and asked for a rule on evictions, and I understand there may be some adjustment in the different times of notices that may be required under state law, et cetera. But to the extent this special committee starts to say, well, we think we need to regularize the procedure in a different way or engage my committee, I'd certainly like to be involved rather than have a piece of legislation come out and have to.
Well, happily, we have Tanya, who is serving on both committees. So Tanya, we'll look to you to be in touch if you think that Alan might want to engage with your committee. That would be great. But I think for the moment, you've heard our comments, and I think let's move on to the next. Without further comment, I would suggest we move on. We still have a quorum, right, Eric? Even though we're missing, do we still have Barbara?
Yeah, you got, oh, wait. Yeah, you got Tom. Yeah, I see 5, right? Or 6 even.
I have 6.
Yeah, you're good. Thanks.
Okay, because I only see 5 of us. Okay, great. Then
Yeah, sorry.
Alan, let's move to the confirmation of, this is conforming to a bill we already passed, the 11E 4356. Should we take that? Should we look at that? This is also another proposed rule, and we have not yet reviewed the next 3. And then, so should we, instead of an oath, this is the declaration piece.
Yeah, I'm trying to put the copy of the rule up on my computer. Bear with me.
And then we have 2 e-court pieces that we need to do.
And Senator Clarkson, if you want any of this up on the screen or up on everyone's screen, just let me know and I'll share it. Otherwise, I won't.
Great. I'm not committee. I'm not sure we need it because we all have it. And it's not, unlike the things that were emergency rules that we were making permanent where we didn't have the language, it was really helpful to see that language.
Okay.
But this, Alan, I think is instead of an oath, you can now make a declaration. Is that right?
Right. We had, during the pandemic, a lot of minds independently realized that to avoid the problems of personal contact, we could allow a declaration in lieu of an affidavit. And that just means you sign under penalty of perjury. You don't need to be in front of a notary public. The legislature adopted a rule that applied only to electronic filings. And so there was, during the pandemic, there, at least initially, self-represented litigants who don't electronically file had no way to do a declaration. We adopted a rule that was a little conservative that said you can do a declaration unless the particular requirement for an oath comes from a statute. And that required self-represented litigants to try to figure out whether the particular rule in question had some statutory basis or not. And it was a big exception, so that it became kind of an obsolete rule as soon as the legislature changed the declaration statute to apply more broadly beyond electronic filings.
Right.
And what I encouraged my committee to do was to ditch the old limited declaration rule with an exception for statutes and carve out acknowledgements, as if you will, or notarizations. So the statute applies to oath, statements under oath, affidavits, or other notarizations. And to me, a notarization usually is in a deed. You appear before a notary and acknowledge that this is your free act and deed. Well, we don't follow those don't happen in litigation. So we've proposed a declaration rule that is limited to statements under oath and affidavits, but has no exception. It just says you can, whenever a rule, let me read it for you. Whenever these rules or a court order requires the filing or service of an affidavit or statement signed under oath, a party may instead file or serve a document signed under penalty of perjury with the following language, the declaration language. And so that's a broader rule that encompasses everything that we'd expect to see in court, and you don't have to do any cross-referencing to see if it applies. There are exceptions in your declaration statute, but in my judgment, they don't involve affidavits or statements under oath. So this was intended to simplify and put in a single spot in the rules how a declaration can be used in court.
Right. Thank you. Any comments, committee? Martin's already weighed in, so he said he had no comment on this. Nodder, Tanya, Randy, Tristan? Okay.
The other thing we did, I'm sorry, I shouldn't, if you're done, I shouldn't speak. But
No.
the form of the declaration says on information and a belief or something like that. And I was afraid people would be signing declarations in this required form and filing them in support of motions that required personal knowledge. And so we've modified some language in Rule 56 to say in Rule 56, you can use a declaration as well as an affidavit, but cautioning that the declaration has to be on personal knowledge to support a summary judgment motion. So we've had a little more time with the leisure after the emergency to I think simplify and improve the declaration rule.
Good. Great. Thank you for that work. So I think without comment, let's move to the two e-court proposals. And comments again are due in December, right, for this?
Yeah.
Okay, terrific. Let's move to the D and E, which are the two e-court ones. One is purely technical and the first one is not.
Okay. We had, this deals with appeals from municipal bodies to the environmental court, and an quote unquote interested person has a right to participate on an appeal and also to appeal. But the way the procedure was working was that once the notice of appeal is filed, the municipal body was supposed to go through their record and provide a list of all the interested persons, which is not always a simple chore. Did they have to speak during the meeting? Did they have to sign their name on a sign up? Did they have to introduce evidence? And what about virtual meetings, that kind of stuff? But in the meantime, so there can be some delays in getting that information and getting the notice of the appeal out to other interested parties. In the meantime, the applicant, who is always an interested party, may have no idea that there's an appeal, and and that has caused some grumbling, if not problems. So we had a lawyer who's well versed. As I understand, he's a chair of one of the municipal bodies, but also has an environmental court practice, and suggested that we make some changes to the rule to make sure the applicant would get notice right away. So that's what this rule provides, that the notice should go out at the time the notice of appeal is filed. The notice to the applicant of the notice of appeal should go out at that time.
Okay.
We also engaged the environmental judges, and they seemed to, they were, yes, they support this in general.
It seems that makes sense. Any comments, committee? Has Tanya left the meeting, or is she just? How many do we need?
Her video is off, but she's still in the meeting.
Okay, great. Good. Okay, great. Oh, good. You're still there, still with us, because we need you. So no comment on this committee? People out of, okay, great. So Al, let's do the final one, and then we will move to Emily and have discussion about our process and Odyssey.
These technical changes to the environmental rules, Emily wrote, and so she can speak to them if you have any questions. But there was a obsolete reference in the environmental rules to the 2010 electronic filing rules.
Right.
And the solution was, rather than was simply to delete them.
Right.
There's no need to have any reference at all, because everyone knows the electronic filing rules apply.
Great. Good.
come up?
So I would, Emily, do you want to make any comment about this, or do you want, should we, Emily, are you in the room?
I'm in the room.
I see you. Oh, good. Good to see you.
Nice to see all of you.
So we still have Tom Burdett and we still have Tanya. So we still have a quorum for a bit. Emily, do you want to make a comment on that? Or are you okay if we all move forward into our discussion of our process?
I don't have anything further on the environmental court rules. I think you perfectly described them as technical amendments to remove those obsolete cross-references.
Yes.
Excuse me, on your comment on the sheriff's, the alternate service of process, is there going to be something in writing from you, or am I to rely on my notes when I go back to the committee?
I think there'll be something in writing from us. Eric, I think we'll be sending, is that correct, Eric? That we'll send that comment to Alan?
Don't ordinarily do that, no. They ordinarily would be in the minutes, and then the committee can glean from the rules committee, not your committee. The advisory committees can look at the minutes to determine what it is they want to proceed on.
Okay.
I'll rely on my notes, and if you send me Garrett, I can get a copy of your minutes when they're done.
Yep, sounds good.
Great, thank you.
Yep.
So thank you so much, Alan. This was terrific. You had a lot, you went through a lot with us. Thank you very much. Thank you for your work. And without further ado, given the time constraints of other committee members, we'll say goodbye to Alan. Thank you. Have a great day. And let us move to a discussion with Emily about our procedure and meetings, and how nice to be actually in a comment period before things have either been promulgated or actually put into effect. So, Emily, I'm going to give the floor to you. We also, I don't know if you heard, but the earlier discussion about Odyssey and some of the challenges with the rules, we just asked for an update on how Odyssey is doing, and clearly it's also presenting some challenges that we need to address in rulemaking. So, should we talk about our process and procedures and our meeting schedule?
Good morning, Emily Wetherell, Deputy Clerk of the Supreme Court, for the record. Thank you, Senator. I think we had a little bit of a discussion at the last committee meeting about trying to make sure that we had some regularized and predictable meeting schedule. I know that in the past, it's been very difficult for the committee to find a time to work on this, on this committee during the session. So with that in mind, I guess the one request that I would have for the committee is knowing that there will be rules that will be promulgated with an effective date of July 1st, and they have to have a 60-day period between promulgation and effective date. That means they're going to be promulgated May 1st. So if at all possible, it would be great to have a meeting sometime before that May 1st date, which I know usually is before the session is over. So I guess that would be a request to your committee to meet sometime in April if possible, or even, before that. And then after that, I guess, if there could be a meeting late summer, early fall, August, September, and then in December, because the December meeting would allow sort of a cleanup of any rules that are on the the docket before the session starts.
I think that is a terrific suggestion. And I actually have been thinking about it. And obviously I'd love to have the committee weigh in, but it strikes me that if we meet 3 times a year, that is good. That we meet after crossover. So after crossover, our load is for a couple weeks a little lighter, and we could probably fit in a meeting after crossover. So late March, early April, last week of March, first week of April would be ideal for a meeting, and we'll figure that out. So Emily, thank you for that. You're absolutely right. We have to meet before our July 1st, before May, definitely. And then I would suggest exactly that we have a late September, early October meeting, and then have a final meeting in December. So those 3 meetings would put us in sync with the January 1st, July 1st effective dates for rules. And you saw committee in this discussion, it was, you know, I think it's much more productive to actually be able to make comments when comments are alive and welcome, as opposed to after after the work is basically finished.
And Senator Clarkson, maybe also if I could just add, you know, over the years, Eric and I have tried to be in communication. So if there are items that for whatever reason do need to be on a faster timeline, for example, if there is some sort of emergency, I have not had a chance yet to speak to Judge Davenport about the issue that she's raising. You know, usually if there's an emergency rule that goes out for comment, I mean, an emergency rule that gets promulgated effective immediately, there still is a comment period. And so this committee would still have an opportunity to look at that, that rule during that comment period before the rule becomes permanent.
Right. I think we would like to meet. We could have a very short meeting to address that. I mean, it doesn't need to be a 2-hour meeting is the point. So I agree. And if we did a December meeting this year, I don't know if we have, that might be the time when we could address that.
Yeah, I don't know enough about it to know how urgent it is or what the
committee, does that time frame work for you, that we would meet after crossover, end of March, early April? We would meet again in September, early October, and then last meeting in December to do any cleanup and or emergency rule work that we need to do. Tanya?
That seems perfectly reasonable. My only concern, and you certainly are much more familiar with the cadence of the legislature than I, is that that end of March, early April meeting might actually be too far after crossover, and it might be when stuff is starting to pick up, and we might need to think about shifting to mid-March, mid to late March.
Right. The only challenge is that the money committees, that we don't go through that final piece of crossover until usually the last 2 weeks of March. So let's just play it by ear. But I think the objective is to do it after crossover, when we have a little bit, we could breathe a little bit more easily. But doing a meeting, and it doesn't necessarily need to be 2 hours. It could be maybe a little, we'll see how it plays. So does that work for everybody? Okay, we'll see how it works, and we're flexible, and can always make adjustments.
Senator, I have a 10 o'clock I need to go to, so I apologize. I have to really have to step up.
It's a 9:45.
Yeah.
Yeah.
Okay. So the last piece, I think, just so are you, Tristan and Tanya, are you both bidding us adieu at this moment?
I am. Yeah.
Okay. The rest, we don't need a thank you for your work. Thank you for joining us today. Could we just hear about an update on Odyssey and how it's doing? Which would, and I don't know if Tom Burdett is still with us. I hope he is.
I'm here.
Okay, good. Emily, do you have just an update on how things are doing with Odyssey? Are all the quirks and quarks worked out?
Thanks for asking. Well, I would love if there was a day when all quirks were worked out of everything, but that's why we have committees like this. I think really all that I can report at this time is that there is a court users group that has been regularly meeting with the leadership at the judiciary, including the court administrator, who sends her regrets for not being able to be here today and wishes she could be with the committee in person. But there aren't, I did communicate with her this morning, and she indicated that there aren't any major issues that have been brought from the court users group. And there's also the change advisory board. That's a internal mechanism that the judiciary has to look at any suggestions that are being made for how to change the way procedures are working through the e-filing system or with Odyssey. So if you want more in depth than that, I would say maybe we should make sure that it's a date when the court administrator could be here.
I think that sounds good. And it also, Amy brought up an issue, a rule change that needs to be made as a result of a challenge with Odyssey in the family court. So I think in December.
I don't
we can
know actually anything of, I don't really know what that, I haven't had a chance to speak to her about that yet.
I realize that. So it's a little premature perhaps. So perhaps if we schedule an early December meeting for this year, we could do that. We could have an update on that.
Yeah, it sounds like her committee is meeting this week. So that would give whatever action that committee has decided to take time to work its way through.
I think that sounds good. And I think then we are done. Eric, is there anything else? Emily, you have anything else?
I don't have anything else. Thanks just to the committee for its time and always for its really thoughtful and helpful comments.
Thanks. Yeah, I thought we had some good discussion. Great. Well, then I would accept a motion to adjourn unless Eric has something else we need to address.
No, thank you, Allison, but I think you did a great job and you've covered everything.
Okay, committee, all set? A motion to adjourn, somebody?
So moved.
Right. Second, all those in favor? Aye.
Aye.
Great. Thank you all. This was terrific, very productive. And Eric and Mike, thank you for your help. And Emily, also, thank you so much.
Very well.
Have a great
Bye.
day.